My topic today is Jogee. You will all be fully aware of the case of Jogee and the way that it changed the landscape, if you like, of joint enterprise. But the question is, did it really? Is the PAL doctrine now a thing of the past? Did the Crown and Jogee put paid to unfair joint enterprise convictions? Does an overwhelming supervening act or event exculpate liability? The Supreme Court was asked to review the doctrine of parasitic accessory liability and to hold that the court, or the courts, took a wrong turn in the case of Chan Wing-Siew and the cases which followed it. In the opening paragraph of the judgment, Lord Hughes and Lord Tolson used the following words: "It is a fundamental principle of the criminal law that the accessory is guilty of the same offence as the principal. The reason is not difficult to see. He shares the physical act because even if it was not his hand which struck the blow, ransacked the house, smuggled the drugs, or forged the cheque, he has encouraged or assisted those physical acts. Similarly, he shares the culpability precisely because he encouraged or assisted the offence." Their lordships went into the history of this area of the law, starting with the Accessories and Abettors Act of 1861 and going through a plethora of cases up to Chan Wing-Siew and the cases that followed it. Putting aside cases of parasitic accessory liability, the basic principle of accessory liability was said to be at paragraphs 7 and 8. Paragraph 7. Although the distinction is not always made in the authorities, accessory liability requires proof of a conduct element accompanied by the necessary mental element. Each element can be stated in terms which sound beguilingly simple, but may not always be easy to apply.